In this case, Qantas and Air New Zealand sought the authorisation of the Australian Competition Tribunal for them to combine some passenger and freight services in a way that would lessen competition in the trans-Tasman aviation market. In such cases, the Tribunal considers what the anti-competitive conduct would be and then any public benefit arising from the proposal. This involves defining the market, then making predictions about the operation of the market if the proposal is authorised. That process almost always requires the assistance of expert witnesses, usually economists who specialise in competition policy. Their role is not to take over the Tribunal's decision, but to support that decision by providing analysis of the current and future operation of the market. However, experts are engaged by parties who are paying their bills. There is a natural tendency for experts to want to support the views of whoever is paying the bills. The Tribunal said, the role of expert witnesses appearing before the Tribunal is to instruct on areas of specialist knowledge in a manner that is ultimately designed to inform rather than to advocate a particular view. Obviously, parties will call upon experts whose opinions support their view of the case. However, it is not appropriate for an expert witness to act as an advocate for the instructing party at all costs, and professional witnesses should be willing to concede points which, whilst not advancing the case of the party engaging them, they believe to be open as a fair and reasonable assessment on the material before them. The Tribunal went on to explore how it could tell whether an expert had become too partial to their own side. The Tribunal said, whether an expert's opinion is confined to his or her area of expertise, and whether experts state the factual basis upon which they have formed their opinion, are useful considerations in determining at what point an expert witness ceases to be impartial and has moved beyond the bounds of legitimacy into advocating for a party. Another indicator is the willingness of an expert to respond to questions whose answers may provide support for a view which is contrary to the interests of the party calling them. This case confirms that experts before the Tribunal, and experts generally, are inevitably not entirely neutral, but they can't become advocates or warriors on behalf of the side that has called them.